With all this talk about the court systems, it's worth spending a little bit more time and talking about the actual stages of litigation. And those stages are what happens at the trial court level. Before you actually get your day in court, there's a fair amount of legwork that's led up to that. So walking through the steps of a lawsuit begin with the complaint. And in the complaint, the plaintiff, which is the person who is suing, explains to the court what wrong they feel has been done to them. They have to also let the court know that it has jurisdiction, and by that I mean the power to hear the case. As a resident of Maryland, Maryland courts have jurisdiction or the power to hear issues that I bring before it. If I had property located in Maryland, Maryland courts have jurisdiction over both the people and the property located within its borders. So in my complaint, I explain what legal wrong has been done to me. I explain the jurisdiction that the court has or the right to hear this case, and then I explain what is it that I want in terms of a dollar value. After swearing out the complaint, I send it to the defendant. However, a lawsuit is not commenced until there is service of process. When we were talking about those procedural rules a while back, a procedural rule is that a lawsuit is not begun until the other person has legally satisfied the notice requirements, meaning I've been given official knowledge that someone is suing me. At that point, the defendant has a certain amount of time to respond to the complaint, and that's called the answer. And in the answer, I have to admit or deny each allegation contained in the complaint, and I have to file it in a timely manner. If service has been properly made, but I don't file my answer in time, then the plaintiff gets a default judgment. Once both parties have filed the complaint and the answer, then the process of discovery occurs. Now, the complaint merely contains allegations of the harm. I have not submitted to the court any proof. The discovery phase is the process by which both parties gather the proof to substantiate the claims that they have filed in their answer and complaint. And there are a couple discovery tools. The first is deposition, and in a deposition, which is particularly useful if you're suing an organization or a corporation, is you can bring in the CEO, and under oath, they are required to answer certain questions that substantiate the allegations contained in your complaint. You can also request certain documents be produced, and that's called a request for production of documents. In situations like that, the other party is legally compelled to disclose and present to the other side necessary documents that they need to substantiate the case. At the conclusion of the discovery process, you move to trial. And this trial process brings together many of the things that we've talked about already. The plaintiff, or the person initiating the action in a civil suit, will have to make their case by the preponderance of the evidence, which, if you remember, was 51%. If the plaintiff has elected for a jury trial, and again, if you remember, the plaintiff has the option of electing a judge or a jury, then you have the jury selection process begin, and that's called the voir dire process. To ensure that people have fair, unbiased jurors, the voir dire process is a screening selection done by the attorneys and the judge, where potential jurors are asked if they know either of the parties, if they have backgrounds in areas that could prevent them from being fair and unbiased in a particular case. After the jury is impaneled, then we proceed to the actual opening statement. What's really interesting about the opening statement is the plaintiff's attorney gets up and gives the jurors the coming attractions. Nothing said during the opening statements has been admitted into evidence, and the attorneys are very careful. During the opening statements, they say things such as, "You will hear," and all of those things have to be substantiated through evidence or witnesses. After the opening statement of the coming attractions, then the plaintiff actually presents their case, and they bring their witnesses who can explain through either direct accounts or through documents the allegations contained in their complaint. After, through direct examination, they tell their stories, then the defendant's attorney will come and cross-examine. And the point of cross-examination, as shown in many Hollywood movies, is to impeach or call question some of the things that has been said by the witness, and that's called cross-examination. At the conclusion of all of the plaintiff's witnesses giving their testimony, the plaintiff case rests. Then the defense attorney goes through the same process of having witnesses placed on the stand that can directly substantiate the claims in their answer to the complaint. At which point the plaintiff's attorney, after their direct examination, gets to cross-examine the defendant's witnesses. After all the evidence has been presented, both sides give closing arguments. Now, the point of the closing argument is to summarize the testimony of both sides, to poke holes in the other sides if warranted, and to substantiate your case. Then both attorneys sit down. What's really interesting is, especially in jury cases, up until this point, the jury has received no education at all on what the law is. So if I'm suing for malpractice or defamation, you've heard an entire trial without being given the legal definition of what defamation or malpractice is. That comes in the form of the jury instructions. After both sides have rest, the judge will give to the jurors the jury instructions. And what that does is take the components of the law and breaks them down into a series of questions. Do you feel that the defendant's doctor was negligent? And it will provide a definition of negligence. It walks the jury through all of the causes of action or the harms, and in legal terms, that form the basis of the lawsuit. At that point, the jury goes off to deliberate. Keeping in mind the burden of proof that we've talked about before, the jury then renders a verdict. In civil cases, it needs to be a majority, not unanimous, that by 51% we believe that the plaintiff did or did not substantiate their case. On the criminal side, it means to be beyond a reasonable doubt, which is again about 98, 99%, and the decision, because what's on the line, people's freedom or life, has to be unanimous.